Good day and welcome to another Paddocks Club video tutorial. Today I'm going to deal with the second element of my overall talk on the Sectional Title Schemes Management Act. Now, this act, as you know, is in the library and you can look under new pending legislation and you will see all its detail. If you want to go through it and perhaps get more detail of what I've spoken here, I'm just giving you an overview. So, the Sectional Title Schemes Management Act starts with definitions. It's got all the definitions that one would expect it to have. The ones I think are of interest is a cross-reference to the to the Community Scheme Ombuds Service Act. And you will notice as you go through the Sectional Title Schemes Management Act that it's making constant references to the Community Scheme Ombuds Service Act. These two are designed to work together. There's a Sectional Title Schemes Management Advisory Council, and that council is what, for example, the Sectional Title Regulations Board is to the Sectional Titles Act. This advisory council will be to the Sectional Title Schemes Management Act. Then there's also a definition of an owner, which is somewhat upgraded and revamped. In fact, in many cases, many instances, corrected. Section 2 of the Sectional Title Schemes Management Act deals with bodies corporate, and this is largely the same as the existing Section 36 of the Sectional Titles Act and parts of Section 37. Section 3 deals with the functions of bodies corporate, and here it's largely the rest of Section 37. There are two things of interest. Firstly, there's a compulsory reserve fund with minimum amounts, and secondly, a special levy liability is also transferred to a new owner. You'll notice that with the current Act, in terms of Section 37, the levy transfers to a new owner if it's an ordinary levy, but not if it's a special levy. That's been cured here. Section 4 deals with the powers of bodies corporate. It's the current Section 38, and there are just two elements that have changed. A special resolution is needed for the body corporate to borrow money or to let parts of the common property to owners. Currently, the trustees can make those decisions without any owner input, and Parliament has decided to change those elements. Section 5 are additional powers of bodies corporate. In fact, these are the powers that were hidden all over the Sectional Titles Act in Section 17, 24, 25, 26, 27 and 29, and in general terms can be said to be those powers which the body corporate must exercise to make decisions prior to an act of registration or some sort of land survey requirements. So the alienation of areas of common property, the extension of sections, all those sort of decisions are lumped into this new Section 5. Section 6 deals, as a new one actually, although it's got parts of the old Act, it deals with meetings of bodies corporate, parts of Section 1, but with additional features. It caters for the delivery of notices for meetings. It doesn't establish fax and email as primary channels, but only as supplementary channels. It also contains the provision that there must be a maximum of 2 proxies, and that each member has 1 vote in number. Doesn't matter how many sections they own. Of course, when votes are counted by way of poll, then the full weight of the participation quotas is felt. But when votes are counted in number, this Section 6 of the Act says that basically each owner and member only has 1 vote. Section 17 deals with the trustees of the body corporate, and it's largely the existing Section 39. 8 deals with fiduciary positions of the trustees. It has been completely rewritten, but it has more or less the same content. Section 9 deals with proceedings on behalf of bodies corporate. Now, this is the old Section 41, 42, and 43 all put together. Section 10 deals with rules. It's the old Section 35, Section 27A, Section 60, and Section 60A. There's not a lot to comment. All those provisions have been put into it in essence, but there is now a chief ombud, referring, of course, again to the Community Scheme Ombuds Service, substituted for the role of the registrar when it comes to dealing with rules. There's an obligation to examine rules that are lodged, and there's a wider responsibility on the body corporate to hold the current rules, make them available. For example, they have to be held and available at every meeting of the body corporate. Section 11 deals with the effect of quotas and the variation. It's the old Section 32 3 and 4. Section 12 deals with the expropriation of common property. It's the old Section 19, more or less the same. Section 13 deals with the duties of owners. It's the old Section 44. Section 14 deals with insurance of owners. It's the old Section 45, pruned to remove the current Section 45(2). That's the provision that in the case of an overlap of insurance, both by the owner and the body corporate, if the body corporate insurer pays, the other insurer is not liable. That provision has been removed. Section 15 is the recovery from owners of unsatisfied judgment debts against the body corporate. That's the existing Section 47, more or less unchanged. Section 16 deals with the appointment of administrators. It's the old Section 46, but it's substantially expanded and changed. The appointment of administrators is not made by the High Court, but by Magistrates' Court, on the basis of serious financial or administrative mismanagement of a scheme. There is an obligation to hold owner and trustee meetings, to lodge copies of minutes and give the Chief Ombudsman reports at least every 3 months. The Magistrates' Court can also remove or replace an administrator. Section 17 deals with the destruction of or damage to buildings. That's the existing Section 48, more or less unchanged. Section 18 deals with the Sectional Title Schemes Management Advisory Council, which we referred to in the definitions, the members of the Chief Ombudsman, a Department of Human Settlements representative, and 3 to 5 other members who have skills and knowledge and experience in the management of a range of sectional title schemes. 19, 20, 21 and 22 are the final bits. This deals with the Minister's power to make regulations, the necessary amendment of the existing Sectional Titles Act, Act 95 of 1986, for certain transitional amendments, and the short title and commencement. Thank you very much. We'll deal with the rest, the annexures, the regulations, in a following video.